The prosecution may make allegations. They may convert to you matters they fear, apprehensions, but those will never amount to comparing reasons. A comparing reason, Yana, such as to justify the denial of bail, must be a very compounding reason that in law would justify that denial. And I wish to move on, Yana, to demonstrate to you that in this case, no comparing reason has been shown. Yana, the affidavit of number 95590 Walter Oginga, or he's an inspector of police, Yana, I notice, purports to set out the reasons why you should deny bail. And Yana, this is the only document placed before you that should demonstrate to you and convince you as to whether they are comparing reasons or not. And my simple answer is there are no comparing reasons shown in this document. I'm constrained, Yana, because of the nature of this case, to go down a few of the depositions in this affidavit to demonstrate that fact. Paragraphs 1 to 4, Yana, are merely descriptive, they are general. Number 5, the first accused, Yana, and then the second to 11 are senior officers. So because they are senior officers, deny them bail.
So senior officers, you know.
I do not understand that kind of argument, Yana. But also, they are apprehensive. I am apprehensive that witnesses may be, look, and the words are,
Maybe.
I am apprehensive that witnesses may be intimidated, threatened, or interfered with. So here, the operative things is the apprehension, the threats and interference. You know, I have presented a bundle of documents, authorities, and one of the foremost cases I have put there, Yana, it is tagged as number 2 is the authority of George Anyona. It's an old judgment, Yana, by a very respected judge, Justice Potter. I think Nyakudi must have appeared before Justice Potter.
I was in that case, actually.
And he states, in fact, Mr. Nyakundi participated in this case. It deals with this point very, very squarely, Yana. And part of the findings in the Anyona case is a court cannot act on fears. A court cannot act on allegations. A court cannot act on apprehensions. If the court were to do so, several players brought by accused persons, including a player like this, would never be given because the sky would be the limit. And the essence of this kind of general deposition is to make it so general that there is no limit as to what it may be construed to mean. Yana, I would be referring, Yana, to the first page of that authority, going on to the second page.
We kindly be given a copy by Mr. Andugi. He's avoiding us deliberately.
This one is long.
I will give them, Yana, after I finish up.
And everybody knows again.
That's what they said. That's what they told me about the charge sheet.
Yes.
You know, these authorities, time honored, they are there. And we have argued these authorities with my very good friend, Mr. Muteti, and he knows them. They are on the tip of his.
Ask him if he can use some of your suppliers.
I'm reminded, Yana, that the state said they have authorities and they have not yet given us, but we'll still deal with them when they give us. Yana, going on in the authority of George Anyona, Yana, there is a page 16 on top and it refers to the Muragori case and so on. And going on to page 17, particularly you are on page 17, from paragraph E, F, and G, where the judge says, if the courts are simply to act on allegations, fears or suspicions, then the sky is the limit, and no one can envisage any occasion when bail would be granted whenever such allegations are made. You know, what we have in this affidavit? Apprehensions. It is considered, I am apprehensive. It may. It is query, you know, in the footage of the Anyona decision. But I wish, and I wish, you know, to ask you to permit me to go further. The fifth accused has been evading the police. I do not know when they called him or left a P22 for him to attend a police station. And then he didn't go. I do not know, Your Honor. Maybe they are going to show you. On this date, we served him, and he was evasive. But I want to state, Your Honor, that the fifth accused went personally to the police station yesterday, knowing he was going to be incarcerated. And you know these people have been incarcerated for one reason only. It seems today to be jurisprudence that is being developed that for accused persons to be granted bail, they must be guests of the state for a few days. That seems to be what is happening. And this is what they're asking you to do. Keep them a bit longer as guests of the state so that they can feel the pain. There is no other reason, Your Honor, for all these things. Paragraph number 7, Your Honor. The 12 to 15 accused persons are yet to subject themselves to the police and are also persons of inference. So, because they are persons of inference,
They shouldn't be influential people should be jailed.
they have not yet subjected themselves. You know, we have pleaded with you to find that they are out of the country. They went out of the country before anybody had asked them, don't go, come to the police station. But because of that, don't give them bail. Don't give them bail. It says, I'm further apprehensive that the witnesses may be intimidated, threatened, and so on. The principles, Your Honor, have been set. And Professor Ojeda went down this long case, Your Honor. And this is a case that is still pending before you, where the judge clearly made stipulations about all this. You cannot deny bail on grounds like this, that we are apprehensive. What is the apprehension about? What is the evidence of that apprehension? What is the basis of that apprehension, Your Honor? Perhaps if people are not of influence, if they are humble like Wandugi, you may give them bail, but not the 12 to 15. You know, it is not a crime to be a person of influence. It is not even a crime to be a person with money, or even without money. You know, we are dealing with a situation where we have set rules of engagement with regard to bail. And these are not the rules that this inspector is postulating before you. Paragraph number 8, Your Honor. That if the accused persons are released on bail, there is real danger that the intended witnesses may be dissuaded. May be dissuaded. I'm sorry, I'm being reminded, Your Honor, I'm perhaps addressing you in the best Kikuyu English. I'm sorry. Again, I'm further apprehensive. They may be dissuaded from appearing. You know, interference with witnesses is a matter that the court takes cognizance. And when it is proven, the ordinary course is to cancel board. But one cannot presume that it is going to happen, and therefore deny bail in anticipation. It cannot be done like that. Number 12 and 14, on paragraph number 9, exited the country under unclear circumstances. And I believe they are just believed, paragraph number 9, I'm unable even to canvass any point on paragraph number 9 for the sake of time. Number 11, that our investigations have revealed that employees of KPLC have been directly and indirectly been instructed. You know, if some persons are deemed to be witnesses in this case, they have names. If they have been approached in any manner, it would have been so easy to put it in this deposition. I do not know whether the inspector got a little lazy and was unable to put all those facts, but it makes it fatal. He does not give you any reason, any facts to support that kind of deposition. There is even a deposition that investigations are possibly still going on. And one of my colleagues has touched on this. And, you know, because investigations are going on, and you're not told when they may end, don't give them bond. So even if the investigations continue for the next 2 years, let them stay in. What fault of their own is that the fact that investigations have not been completed? Why, Your Honor, should the police cause people to be arrested and detained in police cells when they know they have not completed investigations? Of course, to make them suffer. Your Honor, paragraph 13, accused 2nd to 10th are senior officers holding sensitive departments within Kenya Power. I don't know what that is about. Paragraph number 14, the risk of interference. This matter, Your Honor, is covered. I need another 10 minutes on it, Your Honor. I'm going to go fast. I was looking, Your Honor, the way you are writing and giving time for me to write. That's why I'm sorry, Your Honor. If you give me 10 more minutes, this matter is so crucial, Your Honor. I'll finish. Thank you so much. Number 15, that the accused persons are likely to face other charges in ongoing investigation. They are likely to face other charges. These charges are not before you. You have absolutely no idea what those charges are or when they might come. But because they might just be preferred so that these people stay much longer, deny them bail. You know what kind of law is this? What kind of legal principles are we using before this court? Paragraph 16, there is a danger that they may defeat the cause of justice. Your Honor, even denying accused persons their right to bail without proper cause is an attempt to defeat the cause of justice. And this is what is happening. Your Honor, we argued before you the other day until almost 2 a.m. because of similar things. The persons who are intending and attempting to defeat the cause of justice is the prosecution. Accused persons, Your Honor, are here in deference to the court. They are willing to face the trial, but the right to bail is their fundamental right. Paragraph 19, again, Your Honor, is merely on interference and so on. Your Honor, I just wish to state that and to beg you to find that you do not have any other material from where you may get comparing reasons, save the facts on this affidavit. And I urge you to find that there are no comparing reasons in this matter. Your Honor, I wish to draw your attention to just a few authorities, as I have, Your Honor, passed over to Your Honor on this point. In the first case on those authorities, Your Honor, is the case of Mugunya, Danson Mugunya, the very good decision by Justice Ibrahim. And I have reason to believe Mr. Muteti was in this case. Yes, he confirms he was in this case. So Muteti, on first-hand information, knows the principles established. Do not play around with fundamental reasons. Liberty, Your Honor, is not something that you can look aside. You cannot trample on the right to liberty. I'm grateful for Mr. Muteti accepting that fact. Your Honor, I would be asking you to look at the holdings of Justice Ibrahim And it is in this decision, Your Honor, that the judge ruled that the onus of proving comparing reasons is on the prosecution. Your Honor, I have already urged you to look at the authority of George Anyona, and at page 19 of the authorities, this is case number 3, I have the case of Jehu Gatambaki. In the Jehu Gatambaki case, Your Honor, Justice Bogori, who is still upstairs, Your Honor, made a very, very lengthy decision. Although it was in the old constitution, the provisions of Section 72 are basically what we have in Article 50. And he talks a lot about the presumption of innocence and so on and so forth. Your Honor, he also digests the case of Nganga, which has got basic principles on bail and so on. In discussing the matters of bail, one of the things the judge canvassed and argued on are the rights of the accused person. Based on the presumption of innocence, an accused person cannot be denied bail unless they have negative antecedents. It has not been shown on the part of any one of these accused persons that they have negative antecedents. The other facts that we have been told, seriousness of a case, it is neither here nor there. Every offense in our country today is bailable. Severity of sentence, of course, they do not appear on all this matter. I wish you are now also to refer you to the case of Thuomuramba. It is the fourth case on that bundle. In Thuomuramba, Your Honor, Justice Jagi gave the opinion that where a case is bailable, the court acts against the legislature if it persists in refusing to grant bail. And I'm urging you, Your Honor, to find that in this case, bail is of right, and that you have every right to grant bail. This is the same principle, Your Honor, in the FAVE authority, Jane Wamboi. But lastly, Your Honor, permit me to refer you to Thomas Muthui Nzei. Thomas Muthui Nzei, Your Honor, is a murder case. And again, Justice Ochieng considered a lot of grounds. And among others, he also stated that the allegations of the likelihood of, for instance, interference must be shown by real facts. And ultimately, the case decided that even the fear that a person may abscond is not a compelling reason. All those, Your Honor, are not laid out. Lastly, Your Honor, the matter that our learned colleague, Mr. Professor Ojeda, mentioned to you. This is the case of Nzioka. This is a case that is still before Your Honor. It is fresh in your mind. But Justice Helen Ongundi has gone through all these matters. Interference with witnesses, all these small things put in this flimsy affidavit. And she ruled that they do not accord any compelling reason. I'm urging Your Honor also to be persuaded. In fact, this is an authority that bites this court. And there is a lot of wisdom in it. She considered a lot of authorities in this decision. Your Honor, I wish only to comment with regard to one particular client, and this is accused number 12 in ACC number 26. Your Honor, you have been shown a medical document with regard to accused number 12, James Mungai Jenga. He's an elderly man who has shown great deference to this court. He's middle-aged at 73, and he has very serious medical conditions. Because you are now of the nature of medical condition and the right to privacy, I would not want to read the problems, but let me say, the least of them is diabetes mellitus, a very debilitating medical problem, Your Honor. The others, Your Honor, are in medical terms I'm not able to read, considering my general inability at these things. But I wish Your Honor to give you this. Your Honor, all in all, Your Honor will be doing not only these accused persons great justice, but our country. We are only urging Your Honor to protect the rights of these accused persons. We are asking you, Your Honor, to protect the justice of this case. I'm asking you, Your Honor, personally, to ensure that, as provided in Article 50, these accused persons are ensured or are granted a fair trial. And the right to bail, being granted bail, permits them, Your Honor, to organize their defenses properly, as opposed to when they are in prison. So it goes, Your Honor, to the right of a fair trial. I'm begging you, Your Honor, if you can today, to grant them bail. Thank you so much, Your Honor.
With kind permission.
Your Honor, I'm only on my feet on behalf of the 6th accused due to the peculiar circumstances